We'll go with there. Thank you so much, Rep.
Welcome,
McAfee.
Polly.
Thank you, Chair Craven and members of the Judiciary Committee, and particularly to our lead sponsor, Rep. Carol McEntee, who I know has worked so hard on this very important topic. My name is Patience Crozier. I'm an attorney at GLBTQ Legal Advocates and Defenders, where I focus my work on youth and family issues. I'm also by training a family lawyer who's worked in private practice for numerous years on parentage issues. And I'm also a non-biological parent of a child conceived through assisted reproduction, and I have adopted my own children. I'm a member of the Uniform Parentage Act National Committee, through which I'm in touch with parentage experts nationwide on a daily basis to advance protections for children. I'm currently working in collaboration in numerous New England states on parentage reform, in this session alone, in New Hampshire, Connecticut, and Massachusetts, as well as Rhode Island. The focus on my work in Rhode Island is the best possible substantive legislation we can do. That's constitutional, clear, and best practice, so that all children are protected. To me, there's nothing more foundational than a child's legal parent-child relationship. In my practice, I have seen firsthand the tragic things that happen when there are holes in protections. I have seen a child literally kidnapped and separated from a loving, non-legal parent. I have run to court with the non-biological parent to ensure that the foster care system did not get her child when the legal parent had a horrible medical emergency. This is not an academic exercise. There are parents in Rhode Island and children in Rhode Island who are vulnerable and hurt by the status quo. I will talk briefly about what parentage is, what this important law does, and certain straightforward amendments we are seeking. So what is parentage? Parentage is, as I said, the legal parent-child bond, from which every right and responsibility flows. The right to support, to medical care, to insurance, to inheritance, to decision-making, and so many more. Rhode Island has a glaring parentage problem, unfortunately, and it is twofold. First, Rhode Island's laws, if you have heard, are outdated. They're over 40 years old, and only Mississippi and Kentucky have laws this outdated. Rhode Island does not treat all children of unmarried people equally. There are no protections for children born through assisted reproduction. Rhode Island allows surrogacy, but there are no regulations to serve as guideposts to enable children to be protected as soon as possible after or before birth. There are substantial holes. The second issue is that because of these holes in protections, the only route to legal parentage for so many families is through adoption. And in Rhode Island, the adoption system appears to be broken for many families, particularly LGBTQ families. For parents who have planned and worked incredibly hard to build their families through assisted reproduction, the adoption process should be straightforward. Every New England state, but for Rhode Island, has a streamlined process that recognizes these families are effectively confirming their parentage, not establishing it anew. No other New England states requires LGBTQ families to go through the home study process when adopting their children. Massachusetts has not required home studies since 1997. Rhode Island adoption statutes, in fact, allow courts to waive the home study requirement, but courts are still requiring home studies for these families. Rhode Island statutes also allow courts to waive the 6-month residency requirement, but courts are not waiving that for LGBTQ families. You will hear from those families today what this means, an adoption process that's long, burdensome, expensive, invasive, and literally terrifying. What is happening to LGBTQ families is unacceptable and discriminatory. So statutory parentage reform, the province of this body, the legislature, the policymaking body of the state, is one key way to ensure equality by updating Rhode Island law so that all children have the clear route to parentage, regardless of the circumstances of their birth. Now, throughout the fall, I understand there was deep study of this bill by the Chief Judge and by the lead sponsor, Carol McEntee, with input sought from many agencies. They even met with the Uniform Parentage Act reporter, Courtney Jocelyn. Many people have done extremely hard work. And what has emerged is a bill based on the Vermont Parentage Act, which is substantively similar to the Uniform Parentage Act, but some feel an easier framework to use. H7541 is a substantial bill that aims to do many important things, and we support those goals. It makes clear who can be a parent and how to establish parentage. It ensures there are paths to parentage for children born through assisted reproduction, and ensures protections for those welcoming children through surrogacy. It ensures equality for for children of unmarried parents. I have done an overview of all 10 articles of the bill in your written testimony, so I won't do that here, particularly because of the children. There are a few amendments we need to ensure the bill meets the full promise of clarity, consistency, and constitutionality. I think they're very straightforward and not controversial, and I have details of those in my written testimony as well, so I'll be very brief here. In the area of assisted reproduction, 3 changes are needed to ensure that the standards for establishing parentage through assisted reproduction are consistent and clear. In particular, there should not be a presumption of parentage through assisted reproduction in Article 4. That has a different standard from Article 7. No other state has that provision, and it's a core goal of this bill to ensure clarity and protection for children born through assisted reproductive technology. Yes? If you'd like, absolutely.
You're testifying. So.
Sure. Well, and you're asking the questions. Absolutely.
So which section are you in?
Well, there are 3 changes to the assisted reproductive technology provisions that I've suggested. So one is in Article 4, 401A5. The suggestion is to delete that provision because it sets up a presumption of parentage through assisted reproduction, which is in conflict with Article 7, which sets out that if you consent to assisted reproduction, you are a legal parent. It's not a presumption. So we want to make sure there's total clarity. Yep?
I understand from your letter you're suggesting 5 amendments.
Yes.
Roughly.
Yes.
Right?
Yep.
And a couple of extras. And
Right.
I was just hoping to take them one by one. So
Yeah.
you just went through a few. Which one do you want to talk about first? And in what section is it?
Oh, sure. I was just talking about, there are 3, just to group them. There's 3 about assisted reproductive technology and 2 about surrogacy.
Okay.
And so in the assisted reproductive technology components, the first one is the removal of 401A5.
So 401.
We're on page 24. Page 24. What line? Do you have that, Polly?
Absolutely. Let me grab out my written testimony, which has all the lines.
Page 24, okay, I got it here, line 33.
Thank you.
And then it goes into the, then
Yes, the
goes
rep
to
is
the next
right.
page to line 1 and 2.
Yeah.
So we're in Article 401.
Yes.
Right. And which, what do you want to amend?
I want to remove that provision, because as you will see, just by virtue of having a provision in Article 4, okay, the law sets up numerous different, each article is a different way to be a parent, right? And Article 7 establishes how you're a parent through assisted reproduction, Article 7. Article 4 inserts a provision that conflicts with Article 7. It says, you are presumed to be a parent if it adds a presumption of parentage through assisted reproduction, which sets up a conflicting standard from Article 7, which is problematic. And it also sets up, I mean, I'm happy to go through the language in detail. It also says that you have a presumption if you consented to be named on the child's birth certificate, but if you've consented to be named on a child's birth certificate, you've signed a VAP form and you are a legal parent. So that is also just a little bit of a confusion that we don't need in the law.
So is it the presumption of parentage? It seems like it's an and, right? There's Article 7 has one method and Article 4 has another.
Well, Article 4 sets up a presumptions of parentage, and there's 2 broad categories. There's a marital presumption and a non-marital presumption. And when you're a presumed parent, you actually have to do, those are the standards that the court applies if you're trying to establish your parentage through an adjudication, or you can sign a VAP. So if you're a presumed parent, there's the possibility that your parentage could be rebutted because there's other people who have also another claim to parentage. So you really don't want any assisted reproductive technology provisions in the presumed parentage section. You want them all in Article 7, which clearly lays out those requirements.
So are you worried about, what are you worried about there? You're worried about?
I'm worried about someone going to court trying to prove they're a parent, and the court saying, there are 2 different standards here, which one do I apply? And so a child not being able to have their parentage established. So I think it creates inconsistencies that really create on-the-ground problems for children.
Okay. So in Article 7, right, which is parentage by assisted reproduction.
Yep.
Tell me what line and page you're on, please, Jason. Well, I think that, Polly, you're looking to get rid of, in 401A5, it's page 24, line 33 through page
Yep.
line.
Yes, I mean, it's not in the Model Act, it's not in the Vermont Parentage Act, it's not in any other state's act.
Okay.
Okay.
So
Anyway.
Polly, what
Yep.
provision in Article 7 does it, where is the
Does it
provision in
conflict
Article
with?
7 that it's in conflict with?
Because Article 7 talks about that you are a parent essentially by assisted reproduction if you do three things in 7.0. Yes, go ahead.
Can you just point out the page and line specifically?
Sure. Article 703 and 704 are the standards for proving that you're a parent through assisted reproduction.
33 lines starting at 19.
So that's page 33, starting at line 19. Yep, and going to the next page. Oh, it ends on that page. Yeah. And so 703 states that someone who consents to assisted reproduction with another person with the intent to be a parent is a parent of a child. It's clear? You know, with that intent, with that consent, you are a legal parent. You're not presumed to be a legal parent. You don't have to do anything else. You are a legal parent.
So
And then- okay,
I'm
yeah.
sorry, if you were
Go
done.
ahead, please, Rep.
So in line, back on page 24,
Mm-hmm.
line 29, right? So this is the presumed parentage section. In section 4, right, it says you're presumed parent if the individual reside in the same household with the child and the individual and another parent, blah, 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 openly held out the kid 2 years, right? We don't have a problem with that section.
Right, that's the non-marital presumption that's appropriately in that,
Then it says-
absolutely right on in that section.
Or the individual resided with the birth parent entered into the agreement with the birth parent to have the child through assisted reproduction and assume all the duties. Now,
Right.
or the issue is that since we're adding in parentage by signing off on the assisted reproduction agreement in this section, that it can somehow be challenged. Yeah?
That's one worry, yes, and also it's just, so in A5, you have to also have resided with the child, assume all the duties of parentage, and raise the child together as co-parents, and consent to be listed on the birth certificate. So there's a number of different standards in that section that conflict with 703 and 704.
And you're saying, if I hear you right, you're saying that you don't need Section 5 at all.
Right.
Because if you've done all those things under Article 7, you are a parent,
Right.
right?
Yes,
Right?
yes.
So it's
effectively.
almost superfluous.
Yes, yes.
Okay.
Yep. Right, I think the concerns are addressed elsewhere, yes.
Right.
Because I think we all have the same goals, which is clarity of protecting children and clear standards for the court.
Right, yeah, and I think that's, as we go through this, as I've studied it, what I've come to see is that a lot of your suggested amendments are, you're trying to get to good drafting, you're trying to get to good lawyerly crafting, right? And I think that you've hit the nail on the head here, because what we've established here, I don't think it's so much that it's two conflicting sections, it's that this section is somewhat superfluous.
I agree, yeah. And I think I think people have said it over and over again with it, the devil's really in the details here, and a lot of it's drafting. I mean, yes.
Right.
And just, I think, again, we all have similar goals to just make sure that we have the clearest, most consistent language that's not creating issues, unintended consequences. Thank you for pointing that out.
No, thank you. It's hard for me to extract it from like 3 documents going at the same time. It's nice to hear
I
the
hear
human
you.
being tell me,
Yeah.
just make sure I was seeing what I was seeing.
Thank you so much. So moving on to, did you want me to move on to the other amendments
if you don't
in
mind.
that level of detail? Okay. So I think the similar issues with the language in 702 and the language so it's in my written testimony in the 702B and 704B2, raise similar issues of just some.
702 is on page 33, so for those of you who need to see it.
So my suggestion is that the Uniform Act in 702 simply has a clear, that first A, a donor is not a parent of a child conceived through assisted reproduction, and that clarity alone is all you need in 702, because 704 really does the hard work of saying when is a person an intended parent, and 704 sets out you can be an intended parent through a written agreement, through other evidence, such as an oral agreement, or through conduct. And by having 702B, you're in fact setting up a standard that's different than 704 in a way that's confusing and could leave some people unprotected who might be intended parents. So again, my suggestion is just simply to use what the Uniform Act language is, which is 702A, and that you don't necessarily need 702B. Well, you don't need 702B. And then moving on to 704B2, again, my concern is I would suggest that sticking with the Vermont language, which is more straightforward, and again, that 702.4B sets up a standard that is, again, kind of too onerous and in conflict with other parts of the code. For instance, if you're raising the child together as co-parents and each consents to be listed as a parent on the birth certificate, for example, that means you already are established as a legal parent. So those are my suggestions with Article 7. And moving on to surrogacy, those are just two changes I've suggested, which again, I think in an extremely long bill, I'm trying to be parsimonious here, which is just 802. I would suggest we should not enshrine a citizenship requirement for family building through surrogacy, when I believe that such a requirement violates the equal protection guarantee of the 14th Amendment, because I think Rhode Island needs to provide access to the courts and access to parentage protections for everybody who resides in Rhode Island. Yes?
804, isn't it?
It's 802.
802 is page 36.
Oh, I see, got it.
Yep, 36. 802B3, line 32.
I don't mean, is this okay? I don't mean to bore everyone, but
No, that's fine.
all right. So can we go back to 702 for a second?
Absolutely.
So in 702, right, we want the parental status of the donor, and we
Yeah.
want the act to say a donor is not a parent,
Mic drop.
period, right? Period.
Yep.
The donor is not a parent.
Yes.
But then we look at what's in our bill here. It says a person who provides parts, right,
Yep.
to be used for assisted reproduction to a person's spouse is the parent. And that's the objectionable part, because on the one hand, the uniform law says donors are not parents, period. And here we are saying, in the draft that we have before us, donors are not parents. However, if you're a donor
Who is?
to someone that you're married to, then you are a parent.
Which I think is actually fine. I mean, I think that should be the law if you're giving, but that's
Well, what-
covered in 704. Yep.
Right, so that's what I'm wondering, right? So I think that I think we're in one of these situations where there's language here that we may not necessarily need because it's covered in other parts of the bill. So when I look at 703, I see a person who consents to assisted reproduction, right, with another individual, right?
Yep.
That's going to cover the donor spouse,
Absolutely.
right? So
Absolutely.
this House language that you want changed essentially says a donor who's a spouse is a parent, but we already have language that you don't object to that says, no, if you agree to assisted reproduction, right, and you're going to give parts, you're covered under 703.
Yes.
That section in 702 is superfluous.
Absolutely.
Okay, thank you.
Thank you.
See, I have to say that I don't think this language in B necessarily hurts the cause. I just think it spells out another,
I
maybe
agree
it's
with,
more wordy than you would like. It is something that the chief judge was interested in having in this bill. That's why it's there. And having spent so much time with him in the last Oh, since September. I understand where he's coming from. I mean, they see the worst of the worst in family court. I mean, that's where we see the families broken to pieces, or parents who should not be parents. And he just wanted this language to be clear. And my own opinion is, it doesn't hurt the cause. It doesn't hurt the bill. But, you know, we can go over that at another time.
Absolutely. Absolutely. I'm
yeah.
happy, again, I'm looking forward to working with this committee, and, because I think
Right.
we're 95% there.
I think we are.
Absolutely.
I think we really are. And that's a huge leap, is what I was trying to
Absolutely.
say earlier.
And I appreciate your patience, like I said, I know I've said it before, but
my
I think it's
name.
worth saying it again, right? Of walking through this with me, because that's, I'm not so sure that all the players have been in a room at the same time. I know you did this in the Senate, but,
Yeah.
you know,
Well, yeah.
you got to do phase one, phase two, right? So, all
No,
right, so.
I appreciate the care.
It seems like we're solving 702, and the next amendment that you're
Well,
looking for.
How we solving, we didn't make a commitment on this yet, on taking that language out? Is that what you're saying? I just have to intervene here.
You're the sponsor.
I am, okay. We're willing to look at it.
Right. In 704B2,
Yes, sir. I have suggested that we use the Vermont language instead, which is simpler and more straightforward, and I think speaks to what this section is intended to do, which is essentially say, another way to prove consent is through conduct, that you have, acted as a parent, and, I will have to pull out the Vermont language exactly, which is more straightforward. My concern is here it sets up a standard that is, again, in conflict with other provisions. And for instance, if you have consented on line 34 to be listed as a parent on a birth certificate, you have signed a VAP, or you're married, so you are a legal parent. So I think the conduct language needs to more mimic the Vermont language.
I have your language right here,
do
Polly.
you?
So,
Much better prepared.
704B2 in the Vermont law, and you're saying you don't like line 32 through 34, that's on page 33 for anybody's looking.
Right.
You wanted the person resided with the child after birth and undertook to develop a parental relationship with the child.
Yes, that is what the Vermont provision says. Yes.
so that's, I mean,
Pretty close.
do we, we're okay with that?
I mean, I think that the
I don't
language
know.
of.
I mean, I think
Yeah.
the two, what's in here and what's Polly's suggesting are very close. I think we can work it out.
Paula, can I ask you this?
Yes.
So if I say, I want to try to approach this from a different angle. In 704, if I say, consent to assisted reproduction, that a consent is valid, let's just go through the language that you don't like. The parties resided together and decide to have a child through assisted reproduction and assume all the duties and responsibilities of parentage, blah, 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 and the rest of, and the rest of that paragraph. Is that accomplished by entering into the assisted reproduction agreement?
Yes, so like so A says, hey, you can show your consent through signing an agreement, right? That's like
Right.
the clearest way to do it. That's the clearest way. B says, in the absence of a record, you can show that, you can prove that before conception or birth, you entered into an agreement that you intended to be a parent. So like an oral agreement, right? Like you show, you.
Right.
And then so B2 is really supposed to be that, so if you don't have an oral agreement, you don't have a written agreement, you should still show through your conduct that you consented to assisted reproduction to be a parent. So I think that one issue is resided together, because not everybody resides together, particularly when parents come into dispute and are having to prove these things, they often are no longer residing together. And to assume all the duties and responsibilities of parentage, I think that's not so, that kind of works. But the standard of to raise the child together as co-parents, I think is not a standard I'm familiar with in other laws, and I think, I'm not really sure how you would define like a true co-parent, like nobody's really, no relationship is 50-50, that's a difficult thing to prove. And that each consents to be listed as a parent on a birth certificate, again, that is in itself a written agreement.
So I think if we're being intellectually honest, half of this paragraph we could call surplusage once again, right?
Yes.
All right.
Yeah, but this is
So,
all about assisted reproduction, so he puts the words.
All right, we should be able to get there.
Thank you. Should I move on to the surrogacy briefly? Okay. So I think we discussed the citizenship requirement, which again, I think is just a straightforward, Vermont and Maine use a resident requirement that one person has to reside in the state. I think a citizenship requirement violates the Equal Protection Clause of the 14th Amendment, which is outlined in my memo. In Section 804, I have also suggested some changes to that. My primary concern with 804 is that putting different court processes in place for intended parents through surrogacy based on whether or not they're genetically connected to their child. Genetic connection in Article 8 is not a legally relevant distinction, and making some parents endure a more onerous process to establish legal parentage, I think, is unfair and hurts children. So those are just the two pieces of the surrogacy provisions. And again, I have details in my memo and happy to collaborate with the committee on working that language out. So in any event.
Wait, hang on.
Oh, yes.
Sorry.
Go, please.
Can we just, for the viewing public, can we go back to
Yes.
the equal protection thing?
Yes.
Because all the lawyers know what you're talking about, but.
Sure,
Can
yes.
I suggest a situation to you, and maybe you tell me if it's an equal protection violation?
Yep.
So if we pass this law as written with this citizenship requirement, let's say we have two grad students at, well, one at URI.
Yeah.
right, and one at Brown, who are not from the United States, like. Well, all right. The next example, I'll throw some PC in. So we got a grad student from like Japan is at Brown, and we have a grad student from, I don't know, India at URI,
Yeah.
and they meet at a PC hang somewhere, right? And they get together and they fall in love, and they want to have a baby, and they want to do it by surrogacy, right?
Yes, right.
If we pass that law as written with the citizenship requirement, they would not be able to do that, even though they are both making their home in Rhode Island.
That's correct.
Right, and when
Right.
you're a grad student, you could be here a long time, right?
Absolutely, right?
So-
And you could end up getting a position and become a legal, lawful permanent resident and make your life in Rhode Island and not be a U.S. citizen and not be able to establish your parentage through surrogacy.
So you could have a green card and
Right.
decide to live, which, is a permanency document, decide to live your life in Rhode Island, but you'd be denied access to this law. And that is the evil that the 14th Amendment seeks to prevent. Is that correct?
You're absolutely right. The 14th Amendment was specifically enacted so that states treat everybody residing within their jurisdictions equally.
Thank you.
Thank you.
So my question is, let's see, what line are we on at this point? 36, line 32, right? Should we should at least one of the intended parties, now we're talking about 32, it says at least one of the intended parties shall be a citizen of the United States. I don't think that's the one you're objecting to.
Yes, well,
Because that's one of the parties, that could be the surrogate.
well, I think there might be a typo there because I think if it didn't say, if it says I think it's supposed to say intended parents, because
Well-
otherwise you wouldn't use the word intended there.
If we change from citizen to resident, we're on line 32, page 36. When we say intended parties, there's three parties here. There's the surrogate and there's the two intended parents, obviously, right?
Right, which we would usually say all the parties or the person serving as a carrier and the intended parents.
And my understanding is that generally, the court that has jurisdiction and the place where the birth order would be done would be the state where the child's going to be born and where the surrogate generally lives, right?
Yes,
Okay.
yes. And the Uniform Act, in fact, says, so the Uniform Act, as opposed to Vermont, suggests that one party of that combination resides in the state or one medical procedure takes place in that state, i.e. the birth.
Okay. So,
Because also Women and Infants Hospital is
Right.
kind of a central hub for the southern New England states and does have, I think it's like 10% of births from people out of state. But
Yeah.
if someone provided me that evidence, I might be speaking out of turn. I'm sure we could get that data.
I think
to the
that's why
committee.
we changed it to United States citizen rather than, I think, citizen of Rhode Island. I mean, that was
Yes,
something
no, right,
we-
the intent to try to sweep in that,
Yeah.
that regional nature. I understand that might have been the intent. I don't think it was intended to be unconstitutional for sure. I just think that, you know, upon further research, it would create problems for the state.
But you think it would be okay if we change that to resident of the United States or resident of, we don't want to say Rhode Island, or do we? I mean, I think originally
I
that's
think-
we had
I think we
resident of
wanna-
Rhode Island.
I think we might want to follow Vermont, well, you might want to follow Vermont or Maine and say one party, a resident of the state.
Okay.
Yeah, that's in the Senate bill. They
Yeah.
said at least one of the parties shall be a resident.
Yeah, originally it was Rhode Island,
Okay.
but we were taking into account that women and infants has a
Yeah.
broader scope.
That's very
So that
true.
was, we were concerned about people not wanting
So,
to.
yeah,
not-
another option would be to say the Uniform Parentage Act provision, which allows people to, if there's a medical procedure that's happening in the state, that's certainly an option for the committee as well.
But then that child would have a birth certificate from Rhode Island because
Yes.
it's born in Rhode Island?
Yes.
Okay, right.
So that's the Attleboro exception? That's the Attleboro provision?
That's like the Attleboro exception, that's what we were calling it, kind of. Well, I think we can work, you know, we can work with that. And, you know, if the argument is that it's unconstitutional, then that has to be something that we as legislators have to put a lot of stock in, so. But I think, is that the last one?
That is, unless anyone has questions about 804, I just want to say, I think I've taken enough of your time, but I remain available at any point in time, and obviously I have the great luck to be connected to a lot of people who I think are very smart working on these issues in other states, and I'm happy to do whatever I can to make sure this bill gets across the finish line, and I appreciate so much the work of this committee, and particularly Rep. McEntee, and look forward to seeing this be the year. Thank you so much.